5207. Enforcement involving the state. None of the procedures for the enforcement of money judgments are applicable to a judgment against the state. All procedures for the enforcement of money judgments against other debtors are applicable to the state, its officers, agencies, subdivisions as a garnishee, except where otherwise prescribed by law, and except that an order in such a procedure shall only provide for the payment of monies not claimed by the state, and no judgment shall be entered against the state or any officer, department, board, commission thereof in such a procedure. This section shall not be deemed to grant any court jurisdiction to hear and determine claims or actions against the state not otherwise given by law to such court. So I think that is talking about this is not screwing around with subject matter jurisdiction. 5208. Enforcement after death of debtor, leave of court. Except where otherwise prescribed by law, after the death of a debtor, an execution upon a money judgment shall not be levied upon any debt owed to him or any property in which he has an interest, nor shall any other enforcement procedure be undertaken with respect to such debt or property, except upon leave of the surrogate's court. Surrogate's court, which granted letters testamentary or letters of administration upon the estate. If such letters have not been granted within 18 months after the death, that's 18 months after the death, leave to issue such an execution or undertake such enforcement procedure may thereafter be granted upon motion of the creditor, upon such notice as the court may require, by any court from which the execution could issue, or in which the enforcement procedure could be commenced. A judgment lien existing against real property at the time of a debtor's death shall expire 2 years thereafter, or 10 years after the filing of the judgment roll, whichever is later. So kind of like a lot of information in there. You got the surrogate's court, upon leave of the surrogate's court, which granted letters testamentary or administration. And if the letters have not been granted within 18 months, then you could, move by order to show cause. And the lien expires 2 years thereafter or 10 years after filing a judgment roll. Whichever occurs last. 5209. Discharge of garnishee's obligation. A person who, pursuant to an execution or order, pays or delivers to the creditor or sheriff or receiver money or personal property in which the debtor has or will have an interest, or so pays a debt he owes to the debtor, is discharged from his obligation to the debtor to the extent of the payment or delivery. 5210. Power of court to punish for contempt. Every court in which a special proceeding to enforce a money judgment may be commenced shall have the power to punish a contempt of court committed with respect to an enforcement procedure. 5211. Privilege on examination immunity. The court may confer immunity upon any witness in accordance with the provisions of 5220 of the Criminal Procedure Law, with the provisions of 50.20 CPL for testimony or evidence in an enforcement procedure relating to disposition of property in which the debtor has an interest, or relating to his or another person's claim to be entitled against the creditor or receiver to hold property derived from or through the debtor, or to be discharged from the payment of a debt which was due to the debtor, provided, however, that no immunity shall be conferred except upon 24 hours prior written notice to the appropriate district attorney having an official interest therein. And then it cross-references here to say that 50.10 and 50.20, providing for compulsion of evidence by offer of immunity, appear in the appendix below. 5212 through 5220 are not used. 5221. Where enforcement proceeding commenced. A. Court and county. 1. If judgment is sought to be enforced, was entered in the city court of any city that's not New York City, and the respondent resides or is regularly employed or has a place for the regular transaction of business in person within the county in which the court is or was located, a special proceeding authorized by this article shall be commenced in that court or in the county court of that county. 2. If the judgment sought to be enforced was entered in a district court or by a justice of the peace whose office has been by law abolished and his jurisdiction was replaced by or superseded by a district court, and the respondent resides or is regularly employed or has a place for the regular transaction of his business in person within the county where such district court is situated, a special proceeding authorized by this article shall be commenced in such district court. 3. If it was municipal court outside of New York City, the City Court of New York, or the Civil Court of the City of New York. So this is number 3. If judgment sought to be enforced was entered in the municipal court of the City of New York, the City Court of the City of New York, or the Civil Court of the City of New York, and the respondent resides or is regularly employed or has a place for the regular transaction of business in person within that city, a special proceeding authorized by this article shall be commenced in the Civil Court of the City of New York. So New York City Civil Court goes there. 4. In any other case, if it's in any court of the state, a special proceeding authorized by this article shall be commenced either in the Supreme Court or a county court in a county where the respondent resides or is regularly employed or has a place for the regular transaction of business in person, I don't know what that phrase means, or if there's no such county, in any county in which he may be served or the county in which the judgment was entered. Okay, so that is in any other case. Special proceeding could be in Supreme Court or county court in a county where a respondent resides, employed, transaction of business in person, and if there's no such county, in any county where he may be served or the county where the judgment is entered. 5. If no court in which a special proceeding authorized by this article could be commenced is in session, the special proceeding may be commenced in the Supreme Court or a county court in any county within the JD in which the proceeding could otherwise be commenced, or in any county adjoining the county in which the proceeding could otherwise be commenced. B. Notices, motions, and subpoenas. A notice or subpoena authorized by this article may be issued from, and a motion authorized by this article may be made before, any court in which a special proceeding authorized by this article could be commenced if the person served with the notice, subpoena, or notice of motion were the respondent. So again, notice or subpoena may be issued from, and a motion may be made before any court in which a special proceeding could be commenced if the person served with the notice, subpoena, or notice of motion were respondent. Next is 5222, and that is the restraining notice, and oh my god, that is big. This article is big, so it's going to be in a different video, because I'm not going to get to this. Yeah, it's huge. It's like never ending. It's huge. Oh my gosh. And then there's a 5222-A. I don't know if that's on the test. 5223. Disclosure. At any time before a judgment is satisfied or vacated, the judgment creditor may compel disclosure of all matter relevant to the satisfaction of the judgment by serving on any person a subpoena. The subpoena must specify the parties to the action, date of the judgment, amount of the judgment, amount due thereon, the court in which it was entered, and shall state that false swearing or failure to comply with the subpoena is punishable as contempt of court. 5224. This is a little bit of a longer one. kinds of subpoenas. So you could serve any one of these 3 subpoenas. The first one is a regular subpoena for a deposition on oral or written questions. Then the next one is a subpoena ducis tecum, requiring the production of books or papers to be produced at a time and place specified therein. And then the last one is the one that I think they serve on banks and shit all the time, which is an information subpoena. And that one, you can serve it by registered or certified mail, return receipt requested, with a self-addressed stamped envelope. And the subpoena must be answered by answering the question in writing under oath by the person upon whom served, if an individual, or by an officer, director, agent, or employee having the information, if a corporation, partnership, sole proprietorship. That's not really written too well, but I get the idea, I think. Each question shall be answered separately and fully, and each answer shall refer to the question to which it responds. Answers shall be returned together with the original questions within 7 days after receipt. So an information subpoena, return receipt requested, certified registered mail, 7 days you have to answer it. Where the person serving the subpoena is a judgment creditor, other than where the state, agency, or officer is the judgment creditor, the following additional rules shall apply. Information subpoenas served on an individual or entity other than the debtor may be served on an individual, corporation, partnership, or sole proprietorship only if the creditor or his lawyer has a reasonable belief the party receiving the subpoena has in their possession information about the debtor that will assist in collecting the judgment. An information subpoena served pursuant to this paragraph shall contain a certification signed by the creditor or his lawyer stating the following, and this is in capital letters: I hereby certify that this information subpoena complies with Rule 5224 of the CPLR and 601 of General Business Law, and that I have a reasonable belief party receiving subpoena has in their possession information about the debtor that will assist the creditor in collecting the judgment. By signing the certification, the creditor or attorney certifies that, to the best of that person's knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, that the individual or entity receiving the subpoena has relevant information about the debtor. I. If an information subpoena served on an individual or entity other than the debtor does not contain this paragraph, such subpoena shall be deemed null and void. I. If an information subpoena served on an individual or entity other than the debtor does contain the certification provided for in paragraph I of this paragraph, they may move to quash the subpoena pursuant to 2304 of this chapter, except that such motion shall be made in the court that issued the underlying judgment. Failure to comply with an information subpoena shall be governed by 2308 sub B, except that such a motion shall be made in the court that issued the underlying judgment. That's IV. So bottom line is there, information subpoena, you got to respond to it within 7 days. 7 days for an information subpoena. The bank or entity or individual responding to the information subpoena must respond within 7 days in writing under oath. So it's like a week. 7 days. Just remember 7 days.